this morning, the court ruled that, and matter before the court has agreed upon the parties for a plea. I've been presented with a 3-page plea of guilty form, Mr. Taylor, which indicates you're going to plead guilty to the charge. And on page 3, there are signature lines, and there's a sentence near the top that says, "I entered the plea voluntarily," and then right below it is the signature line. It looks like I'm seeing a signature of Aaron Taylor up there. Can you see that? Is that your signature I'm looking at?
Yeah, that's right.
And
I ain't got my glasses on now.
okay, sorry.
I'll take your.
Did you just sign it here this afternoon?
Yes, sir.
Did Mr. Armitrap go over with you before he signed it?
Yes, sir.
Explain everything to you?
Yes, sir.
Did you understand it's an agreement to plead guilty, which means there's not going to be a trial? The next step in your case would be a sentencing hearing?
Yes, sir.
All right. And think you've had enough time to fully consider this matter before making this decision?
Yes, sir.
You feel you've been rushed or pressured in any way in doing this?
No, sir.
Are you entering into the agreement to plead guilty voluntarily?
I don't understand.
So in other words, you're doing this based on your circumstances. You're doing this
for my best
based
interest.
on your own decisions. What's in your best interest?
Yes,
After
yes,
talking to your attorney.
Okay.
No one's forcing you to do it.
No, no.
Okay. Okay. You're not doing it against your will, in other words.
Yes,
Okay.
yes, sir.
All right. Thank you. Now the charge or the agreement says on page 1, you're going to plead guilty to the charge in the indictment of aggravated possession of methamphetamine under section 2925.11 of the Ohio Revised Code. That's a 5th-degree felony. It further states, as you understand, the maximum penalty for that could be 12 months in prison. The minimum would be 6. There's also a fine available of up to $2,500 and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes,
Now, are you facing felony charges anywhere else?
sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
I'm on a misdemeanor.
Yeah, but not for felony.
No.
All right. Now, under the law, Mr. Taylor, if at any time in the future you should be found guilty of this offense and sentenced to prison, once you complete the term set by the court, the law says that the adult parole authority could choose to put you in what's called post-release control supervision for a period of up to 3 years. And if you violated any of those conditions that they set, they could return you to prison even though you served the entire term set by the court for an additional period of up to 1/2 of whatever time you served under the court's order for one or more violations. But if you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge in the new case can impose, that judge is also authorized to sentence you, in this case, to an additional period of 1 year or whatever time is left on the 3 years of post-release control, whichever is greater. If that occurs, that must be served separately in the sentence in the new case. Do you understand that?
That's only if I mess up
Right.
something else, right?
Right. I'm about ready to explain that.
Okay, sorry.
Okay, no problem. So, I am allowed to put you under community control, which means you don't go to prison, and instead you can be supervised under certain terms set by the court, by the county probation department. Be different from the terms you're under right now in the pre-trial. Now, if they felt that you were in violation of those, they would have to file a written notice of that with the court, and you would get a copy. And then you would be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing was that you failed to comply, then at that time, the court could then revoke it and then sentence you to prison for between 6 and 12 months, fine you $2,500, and then you could be subject to post-release control if that occurred. You understand that?
Yes, sir.
Okay. Now, the charge alleges that on or about October 11, I believe it is, 2020, County, Ohio, you knowingly obtained, possessed, or used Schedule 2 controlled substance with methamphetamine in violation of Section 2925.11. And so that's the charge of aggravated possession of methamphetamine, the 5th-degree felony with the penalties I just described. Now, have you talked with your attorney about the nature of the charge, possible defenses you might try to raise at trial, possible legal issues in the case, and possible defenses, possible outcomes of the trial and consulted with him about that?
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
Always.
Are you under the influence of any types of drugs or alcohol at this time?
No,
You're taking any prescription drugs?
no.
Has anyone threatened you that you plead guilty?
No.
On page 2, there's a couple of bold lines that are printed in bold and underlined and state, as follows. Defendant shall enter plea of guilty to the indictment, state defense trying to recommend community control, and then defendant be referred into drug court. Is that your understanding of the agreement? Does anyone promise you anything other than that to get you to plead guilty here today? Under the law, Mr. Taylor, the matter of sentencing is up to the judge, not the parties. And so even though there's an agreement by both sides, you should get community control probation. I don't have to do that. Once I've heard all the information that's presented at a hearing, including what's happened between the time of the plea and the time of the sentencing, I could decide that's not the right sentence and sentence you to prison instead of putting you on probation. You understand that?
Yes.
And have you talked to anyone about drug court other than your attorney? Anybody probation? Okay.
It's been real fast, so.
All right, well, you'll be referred to them. Now, drug court is a voluntary program in community control. I don't order people to go into that. They have to request to be admitted. And so you will have to talk with Ms. Sturgill or Ms. Davis about that. They'll go over it with you, explain it to you, give you a copy of the program requirements. And then when you come back to court, you'll decide whether you wish to go forward with your application. And then I'll decide whether you meet the legal criteria, whether you meet the criteria for the program that's been established, and whether or not I think that's the right option for you. So I won't know until that happens because there's several things that have to go into. You understand that?
Yes.
Okay.
I do now, I do.
Okay. Do you hold any license or certificate from any state agency or board for any kind of a job or
I've got a Class A CDL, I was in the military for 6 years.
You don't have any like a surveying assistant or
No.
anything where the state issues a license, something like
I don't know if
engineering license or
that type of, no.
yeah, professional licenses. Okay.
I guess I consider myself a professional driver or something like that.
Sure. Well, yeah, but CDLs and driving, you do have to comment. All right, now. You have certain constitutional rights you have to understand before I can accept the plea from you. First of all, Mr. Armitage is appointed to represent you.
I was retained, Your Honor.
Oh, you're retained? Okay, sorry. All right, well, under the law, you have a right to have counsel if you could not afford to hire one, the court would appoint one. And so you employed Mr. Armitage, but if you weren't able to pay him to continue to defend you, you wanted to defend him, or wanted to defend against his charge instead of plead guilty, the court would appoint an attorney for you in that event. And so the reason I bring that up is simply to make sure you're not pleading guilty because you don't think you're going to be able to afford to hire an attorney.
No, that's not the issue.
Okay, great. All right, thank you. Now, under the law, Mr. Taylor, you have the right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens from this county who are summoned for jury duty on your trial day. After they're selected, the evidence will be presented, they be instructed on the law. And then they will decide by a unanimous verdict whether or not the state can prove your guilt by proving beyond reasonable doubt. Unanimous meaning the all 12 have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means give up the right to have a jury trial. And in that event, you would have a trial to the court. And that means the judge would be the one to hear the evidence, apply the law, and decide whether or not the state proves your guilt by proving beyond reasonable doubt. Do you understand that?
Yes.
The Constitution, Mr. Taylor, you have a right to confront witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come in before and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That is called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to be in court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena. That forces those people to come to court to be available to testify, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, except in one situation, and that is if there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, They cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even going to comment about it except in one situation. That is, if there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged by proof beyond a reasonable doubt. That means is that if you don't have to try to prove, let me back up. The burden of proof isn't on you to prove that you're not guilty because you've been charged. The burden is on the state to prove that you're guilty. And so at trial, you're not required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio. Prove your guilt or prove beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally entered a plea of not guilty. That plea denied the allegations in the indictment, denied that you committed a crime, and it exercised or invoked all of the rights that I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegation in the indictment that the allegations are a crime and that you committed that crime. And that plea waives up all the rights I've just described, except the right to have an attorney. You always have a right to have an attorney no matter what you plead, without exception. Your plea of guilty would waive give up the right to have a jury court trial, would waive give up the right to confront witnesses, cross-examine your attorney, waive give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, same as the state, waive give up your privilege against self-incrimination because you're saying you're guilty and that's what she finds you guilty. It would waive give up your presumption of innocence because if you say you're guilty, then the state would have to prove you're guilty. It also subjects you to being tried illegally by the court. And finally, it waives gives up any right to file an appeal that you think you may have had until this point in the case. So, for instance, the court on rule on the suppression hearing, if you plead guilty, you can't appeal that. So you would have to go to trial, and if you found guilty, then you can appeal. And under certain limited circumstances, you can file an appeal, but any appeal would have to be filed within 30 days of your sentencing entry being filed. You understand that?
Yes, sir.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge, the possible penalty? You understand it? Have any questions about the plea agreement? You understand it? Again, you understand that the recommendation of the sentencing is not binding on the court.
Yes.
Do you have any questions as to the constitutional rights I've explained? You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes.
You understand?
Yes.
Right. So anything you'd like to speak with Mr. Armstrong about before we go any further?
Yes, sir.
Have any questions about anything that I've explained to you today? And is it your decision to withdraw your not guilty plea guilty to the charge in accordance with the written plea agreement we just signed? Okay. And as the charge which alleges that on or about October 11, 2020, in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11 in our revised code, charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying possible prison term between 6 and 12 months, fine of $2,500, and license suspension 6 months to 5 years. How do you feel?
Guilty.
All right, thank you. You see me? All right, the court finds in this day open court, defendants advised of all his constitutional rights, made no intelligent and voluntary waiver of the same, pursuant to Article 11. Pleas accepted and ordered filed. Defendant is found guilty of the offense. The case is referred to the probation department for a pre-sentence investigation and substance use disorder mental health assessment. Sentencing will be set for September 22nd at 9 a.m.
Your Honor, I can't do 9 o'clock, I'm definitely kind of gone.
Oh, okay.
That piece.
All right, set for October the 6th then. October the 6th at 9 a.m. So it's, you'll need to report down to the probation department. Do you have an appointment today or sometime this week?
What is it?
You have to report to the probation department. Have you got an appointment set up, for today or later, this week?
I have no appointments.
Okay, you need to contact them and let them know that you, I know you're, with FRS today, so call them and let them know, that you pled guilty, and, they'll set up time to interview you for your pre-sentence investigation. And, you're already in treatment program, so that part won't be hard. But just make sure you continue to apply that program and, make sure you're still there for your sentencing hearing. So, all right, anything further, counsel?
Hang on, hang on.
All right, thank you.
Is there money?